informed me that she which is diagnosed with strep, so she will not be joining us. First, we're going to go ahead and introduce yourself, and then I will just go over the rules very briefly. So,
Hi, good evening. I'm Justice Annalise Bridges.
Hi, I'm Justice Dina Shropoulos.
Chief Justice Raphael.
I'm Justice Andrew Distel.
Associate Chief Justice Winston.
And Deb.
I'm just Deb. I'm just Dante, sorry, and I'm calling in from abroad.
Great. So just to go over the rules. So each side will be afforded 30 minutes. We will begin with the petitioner. The respondent is going to have 30 minutes to follow up. And then the petitioner will be granted a final 5 minutes for rebuttal. Before that rebuttal occurs, we will take questions from Mr. Michael Pell. Both sides may ask a few questions, and justices may read out questions for him as well. For the other people here, you are more than welcome to stay for the case, but please do not leave midway through the case. If you are staying now, you are stuck here the entire time. And if there are any disruptions, you will be asked to leave. All right, so with that, we are going to go ahead and petitioner may start, and for a time for 30 minutes.
Your Honor, before we begin today's proceedings, if I may draw the court's attention to a specific line in the petitioner's original petition, there was a discrepancy that quite frankly, it's a mistake, maybe a typo, I'm not sure, but it could serve to unfairly bias Your Honors.
What is the question?
Yeah, no, so if I may draw your attention to the original petition presented
Yes.
by the petitioners, if you look at the last line on the second paragraph of that petition, I'll give you a minute to get there.
Yes.
That last line begins, if I may read just the entire sentence, it says, or at least part of it, the PASH reform bill passed with a vote of 18 aye to 17 nay votes. That's actually incorrect.
Yes, Mr. Brian Hopkins sent a formal letter explaining the vote count, so that has been explained.
Wonderful, thank you, yeah.
You may begin.
All right. So I want to begin the case. I don't understand.
You may stand at the podium, you may sit, you may do whatever is comfortable for you. And just to note for those unfamiliar with judiciary procedures, justices will likely interrupt you with our own questions. Don't be phased, just do your best to answer them. And continue with the argument.
So I can just set myself on the timer here. So to begin, I'll go over briefly why the petitioning side here thinks that there's a real conflict, and then I'm going to go over why this conflict is important, and then I'm going to try to anticipate some arguments that you might hear from the respondents and explain why they're false or irrelevant to the case. So to begin, I want to read the most relevant clauses from each bill. The PASH Responsibility Act, which is the one passed by me and Senator Jackson Dellinger, and some clauses from the PASH Reform Act by Brunetti et al.
And that was the one that followed.
That's the one that followed. It was passed later on with a smaller margin. So the clauses from the PASH Responsibility Act, Clause 4B, says after this statute, no student, organization, group, or center shall request funding from DSG for any item whose primary purpose is to provide its user with sexual pleasure, nor shall DSG fund such a request. And in Section 5 of Enactment Enforcement, one of the lines says, this statute may only be declared null and void by a statute of the Senate whose explicit sole purpose is the repeal of this statute. Now, the conflicting lines from the PASH Reform Act. First of all, this is a later statute that is funding a request by a student group, or it is DSG accepting a request for allocated funds from a student group after the ban was placed by this original statute. And the justification for why it is able to supersede the original statute is that there is a line in it that says this amendment will directly replace the previously passed budgetary statute of Duke Student Government to fund peer advocacy for sexual health.
Objection, Your Honor, if I may.
Yeah. Yes.
Just a brief objection. If I would ask the opposing counsel limit his responses to what his own argument is. He's speculating as to what our contention will be, and again,
sit down, and no more interruptions will be tolerated, or you'll be asked to leave. Please continue.
Right. So, thank you. The essential conflict here is that the first statute passed banned future allocations of funds to any sexual pleasure products, and the later statute, the one passed by Brunetti et al., did exactly that. It was a new funding of a request for sexual pleasure devices. It was a new statute. It wasn't amending any old one because they were all passed. So it had to be a new statute, and thus was a new funding of a request for sexual pleasure devices, which is banned by the old one. The old one says it can only be repealed by a statute whose explicit and sole purpose is to repeal that statute. I think anybody who's looking at this new act, the PASH Reform Act by Brunetti et al., would recognize that it is not a statute whose sole purpose is to repeal the old one. And this was made clear during the Senate debate, in fact. During the Senate debate, I myself stated the strength behind the enforcement provision was that you could not throw a line into any old statute that said the old one is repealed. That was made clear, and I believe some of the respondents actually asked questions about that particular line. This was made clear to the Senate before they voted, as was mentioned in the petition, I believe 23 to 18 in favor of that bill, PASH Responsibility Act, with what is called the entrenchment clause, and that is how I refer to that relevant clause in the enactment enforcement that says it may only be repealed by another statute whose explicit sole purpose is that repeal. So in addition to the fact that there is some conflict here, and the reason that the PASH Responsibility Act with the entrenchment clause and ban clause takes precedence is that that one was passed first. And seeing as neither of them were either signed or vetoed, they both came into effect 5 days after the time of their passage. Which means the PASH Responsibility Act, its ban clause, and its entrenchment clause came into effect before the PASH Reform Act and its repeal. Meaning that the entrenchment clause and the ban clause were both empowered with full DSG legal weight before the other legislation could come into effect 5 days after its passage. Which means there's some obvious conflict, and it should be rendered invalid because of the ban clause on future DSG funding of requests for sexual pleasure devices, and the entrenchment clause that prevents any superseding legislation that is not explicitly and solely to repeal it. Which I think, if we need to bring out the PASH Reform Act, we can look at it. It is clearly a budgetary statute, not just repeal of the old one. So it's clear that there's the legislative power goes into the entrenchment clause, the ban clause, which should preclude PASH Reform Act from any type of supersession. But in addition to this, even if you would believe that just a sentence thrown in to a budgetary statute whose explicit sole purpose isn't really to repeal the old one, the wording of their phrase that is trying to repeal the PASH Responsibility Act wouldn't even match. It doesn't say that it's a direct repeal. It says a direct replacement, which does not meet the criteria for repeal of the old one as stated and voted on in Senate, which says that, I will state again, this statute may only be declared null and void by a statute of the Senate whose explicit sole purpose is the repeal of the statute, not the replacement. So for two reasons, the PASH Reform Act violated law that was set at least an hour earlier by the PASH Responsibility Act 5 days after the Senate meeting when they both come into power. Now, why should we care about this? Well, in the case Gregory v. Morrison, decided by a DSG judiciary, it was declared that judiciary is not a legislative or executive body. However, the judiciary does have the responsibility to judge constitutionality and make decision between legislations, legislations when there's a problem caused by a student group. On procedural grounds, allowing the PASH Reform Act to stand would be equivalent to saying that the Senate can ignore decisions that it has made previously. It would be saying that the Senate made a decision to vote on something and give it full legal power, and then if they vote on something that conflicts and the legal entrenchment of one precludes the other, that they can ignore whatever the language of the old legislation was. They can ignore that and just say whatever they want. And this sets a terrible precedent, I think, in terms of institutional power. for any DSG body in general. So, I want to look now at some arguments that you might hear from the other side as a little bit of a preemptive defense. So, they might argue that the entrenchment clauses aren't okay because they make statutes unnecessarily permanent. It's fairly easy to pass a new statute whose explicit sole purpose is to repeal the old one.
So would you say that the statute, there'd have to be a statute that explicitly repealed it and then a subsequent statute that issued separate funding?
Exactly, that is what I had in mind, and actually what I mentioned during Senate and during negotiations on the bill, all of which was open and freely discussed. I believe Eddie was actually, or Senator Torges was in the room while I was discussing that with VP Wiseman. So, the bylaws and Constitution are supposed to be somewhat vague and not refer to specific instances of policy because they're supposed to be guiding documents, not directing documents. However, Senate has the power to place more restrictions as long as they're within the guide set by the bylaws and Constitution. And there's nothing in the bylaws, Constitution, House rules, or Robert's Rules of Order that precludes Senate placing an entrenchment clause as long as, for example, the new statute that repeals the old one can still be voted on by a simple majority, is still voted on or amendable. All it says is that that new statute, its sole and explicit purpose must be to repeal the old one, which a replacing budgetary statute does not accomplish, and a budgetary statute in general, which redistributes the funding, also does not accomplish because it's not a sole and explicit repeal.
How often, do you know, are other pieces of legislation written by DSG followed with this kind of language?
Not very often. It is a creative usage of enactment and enforcement clauses. However, I don't think that it should be counted against the legislation that new and creative policy tools were used when those new and creative policy tools were not out of line with what's permitted.
My question is that if this were used in other cases and subsequently were overturned, was there a separate piece of legislation that overturned it, and then there was a follow-up piece of legislation that amended it, or were they combined?
I couldn't point to a specific other case in the past where this has occurred, and there was a explicit statute to repeal and replace, and then followed by a new budgetary statute. But I also don't imagine it would be extraordinarily difficult to do so in this particular scenario.
But you are arguing that they would have to be separate pieces?
Yes, I'm arguing that there would have to be separate pieces, a repeal statute, and then a new one, a new budgetary statute. The purpose of the entrenchment clause, I can go over that a little bit, was to make it so that Senate couldn't just override this agreement that was made this year without even having to remember the agreement. It was to make sure that if there was a future request to, for example, bail out PASH or have new funds, that the Senate would have to at least recognize that there was an agreement made in the past and recognize the concerns that were made in that agreement. It would force Senate to bring back and slow down that process just a little bit, but not an inordinate amount that is out of line with the Constitution or bylaws, and also I don't think an unreasonable amount. And I'll also like to remind the judiciary, the substance of PASH is not what is under debate today, just in case that becomes a question. It is not whether or not the original funds were proprietary or appropriate, which could be a separate case. But the question at hand today is the actual conflict between an entrenchment clause and a ban clause and a subsequent legislation that improperly attempted to supersede and also improperly attempted to extend a new allocation of funds for a request for sexual pleasure devices.
Quick question.
Yeah.
So, and this is just going back to clarify what you mean by this entrenchment clause. So you're looking at three pieces of legislation at that point. So you would need to override, establish whatever, in this case with POSH bill again, and then establish a budgetary shift.
Right. So
Following.
So if I understand your question correctly, I'll explain exactly how it would look. So Past Responsibility Act is good law. It's passed by Senate, 5 days it passed, and it comes into power, comes into effect. That's the first one with the ban and entrenchment clause. In order to eliminate that, there would have to be a statute that has whatever necessary formatting is required in terms of sections, but the only purpose of it, looking at it, is just repeal the old one. That one passes, then Senate would be allowed to say, all right, here's a new budgetary statute to fund PASH. That wasn't what occurred. It was a new budgetary statute to fund PASH, which is against the ban clause, and attempted to get around the fact that it controverted the ban clause by saying, and we also have this special supersession line. And the supersession line, because it is only one line in a much larger bill, doesn't have enough power to supersede the old one. And that's the chief argument today. And because of that, we have two conflicting pieces of legislation. And if the PASH Reform Act, which is from Brunetti et al., is allowed to stand, it creates a precedent that the Senate can ignore decisions that were passed on previously. And in case the argument comes up that that Senate wasn't really aware of what they were voting on, again, I want to highlight, I answered a number of questions on this particular point during the debate, and it passed by a higher margin than the PASH Reform Bill did as well. So even if if you decide to do a cost-benefit type of thing from each bill, there are more aye votes for the entrenchment clause and the ban clause than there were for the other one. And Senate had asked a number of questions about it and clearly understood what they were voting on at the time. So I don't think that it's a legitimate, or I think it's dangerous to say that if they vote against a law that can't be overturned, that you just take whatever, like the executive vice president says is the good one out of the different conflicting laws. So I want to bring up another point here.
I think Justice Devaki has a question.
Sure.
Hi, can you hear me okay?
Yes.
Okay, so I guess my main question about the entrenchment clause, how would you distinguish the latest bill that's passed, the reform bill, from just an amendment on the previous statute?
Right.
From what I see, I understand your argument about the entrenchment clause, but I'm also, like this new reform bill that's passed, it seems more of like an amendment of budget allocation, which do sit under the Senate's prerogative.
Right.
So how would you distinguish this from the normal amendment?
So I think that's a great question. The two responses I have. First of all, it's my interpretation that once a bill is passed, I think this is how the Senate's been operating. Once a bill is passed, it can now no longer be amended. It can be superseded by a new legislation, but it can no longer be amended. So it wouldn't even have been an amendment. And second of all, the PASH Reform Act did not really refer to itself chiefly as an amendment of any past PASH reform or PASH bills. Its title was a budgetary statute of the Duke Student Government. And its purpose was to be a new statute that reallocated or redistributed how the funds were to be given to PASH, which constitutes, as I said before, a new allocation of funding for requests for sexual pleasure devices, which leads to the conflict. Another potential problem that may come up in the respondent's case is that there's a lowercase s used in the word statute, and thus referring to any directive of the Senate, which means any line that controverts, because it's not a capital S statute, which refers to a whole thing. This is one interpretation I've heard and that they may bring up. A lowercase s statute just has to mean one sentence says that it repeals the old one. And again, I'll direct you to the fact that there's no sentence that says it's repealing the old one, it only says that it's replacing. And also I think that that's an abusive interpretation of what a statute is to refer to. So, yeah, so I think that about outlines the case brought by the petitioners today. I'll bring up some responses during the 5-minute period to whatever the respondents would like to bring up?
You're also welcome to reserve the rest of your time for that.
Oh, really? Wow, cool. Yeah, let me go ahead and do that. Thank you.
Go for it. Your time is 30 minutes and starting now.
Thank you very much. Chief Justice, Your Honors, may it please the Court. My name is Michael Brunetti, and I, along with my co-counsel, Edward Torges, will be representing the respondents in the case at bar. Your Honors, the Past Reform Act should be upheld for the following reason. Constitutionally, an entrenchment clause is invalid and unenforceable. Your Honors, at this time, the respondents would like to call Michael Pell to the witness stand.
There will be time for that after your side, as I announced it in this case.
Well, Your Honors, our primary contentions revolve around Mr. Pell's testimony.
Your Honors, if I may. We would like to present you with direct evidence from the witness so that we can then go on to elaborate what bearing that has in today's case. So while I do understand that you may have preferred to call him at the end, it would seriously, it could lead to
I will
potential
grant the
confusion.
request that this will be part of your 30-minute period.
That's quite all right, Your Honor.
Sorry, Your Honor. Thank you.
Raise my right hand or anything?
No, not necessary.
Would you like me to stand?
You can sit there.
Mr. Pell, why are you here today?
I am here because I was asked by you and your co-counsel to answer some questions regarding the present case.
Mr. Pell, what is your experience working with DSG, if any?
I was a senator for 2 years, my freshman and sophomore year, on the Equity and Outreach Committee, and I currently serve as the policy advisor in the Mecklai administration.
Thank you. Chief Justice, at this time, we'd like to admit Mr. Pell as an expert witness on the matter of DSG policy.
Granted.
Thank you. Mr. Pell, is there any precedent that you know of pertaining to an entrenchment clause being present in a piece of DSG legislation?
No specific examples I can recall. I remember at some point during my time on the Senate, it was discussed whether the actual powers of a bill, what the powers of the bill were, and the consensus was that a bill can replace any other previous bill. I don't remember the specific discussion there, but that was just a general statement that was made a lot of the
You
time.
recognize that your own legislation contains the same entrenchment clause, correct?
We do, Your Honor. Mr. Pell, so just to be clear to the court, you have no recollection of there ever being an entrenchment clause in a piece of legislation before the Past Responsibility Act? Never?
Not in my time, that's correct.
But that doesn't mean that it's not allowed, correct?
That's correct.
Have you reviewed every piece of legislation so you can definitively say beyond any reasonable doubt that?
No, simply in my experience, my 2 years when I was a freshman and sophomore, and this year, I do not recall any sort of entrenchment clauses
And are you
in
present
bills
at
that were
every Senate
passed.
meeting?
I was present at the vast majority of Senate meetings. I'm simply speaking on my own experience, not the official record of 2013 and 2014.
Mr. Pell, have you reviewed any documents pertaining to this case?
Yeah, I've reviewed the Past Reform Act, the Past Responsibility Act, the Constitution, the Senate bylaws, and a variety of other general legal principles that help inform my testimony.
All right, Mr. Pell, after reviewing all those materials, were you able to reach an expert conclusion on this matter?
Yeah, I believe that while entrenchment clauses certainly can be present, the words themselves can be present in a piece of legislation, as other countries actually have an example of that. They are completely unenforceable unless there is some sort of particular constitutional authority behind them. This is something that the Supreme Court ruled upon in cases between starting in 1853, I believe, which I should refer to some notes. The first case the Supreme Court took this up was Ohio Life Insurance and Trust Company versus DeBolt. Chief Justice Taney ruled for the court in 1853, overruling the ability of any sort of legislative entrenchment. There were then two subsequent cases between that period and 1898 that upheld the same ruling for both state legislatures and the federal government. So this is something the United States actually has dealt with. The U.S. Constitution doesn't include any provisions allowing for entrenchment. It also doesn't include any specific provisions prohibiting entrenchment. If the Supreme Court, many, many years ago, determined that entrenchment was not allowed. There are a variety of other principles that would uphold those decisions.
But Mr. Pell, you recognize that the Supreme Court system is not the same as the Duke Student Government system, correct?
Yeah, of course. I just think that, in looking for general legal principles, I think that the Supreme Court and international systems are appropriate to turn to, since we don't have anything in our own constitution either prohibiting entrenchment or giving entrenchment any sort of force. So I think when there's not a solid, and there's also no precedent, no judicial precedent for this either. So I think it's appropriate to turn to general legal norms and acceptable systems of laws.
So Mr. Pell, to your knowledge, there is nothing in the Duke Student Government Constitution, House laws, House rules or bylaws that allow for the enforcement of an entrenchment clause, yes or no?
That's correct.
Why would that be?
I mean, it's mostly a practical matter. If you allow it's highly problematic to allow a majority in a legislature to raise the threshold for appeal of future laws, even if the particular limitations placed on future legislatures of this bill are relatively minimal compared to something else. It's the same principle that you'd be violating. So if you allow for entrenchment as a matter of practice, you could have something like allowing a majority in a legislature to include a provision that says 90%, it requires a 90% majority to repeal the provision. But that's kind of strange because then you have a 50% majority raising the threshold to 90%, which is essentially unfair. You could also do things like make it impossible to repeal a statute. You could say the statute cannot be repealed. That's actually what one of the Supreme Court cases was about. The case that Chief Justice Taney ruled on had to do with the legislature's ability to pass taxes in the future. So it would be pretty bizarre to allow a majority at one point in time to bind all future action of all future iterations of the legislature. So as a matter of practice, it would just it'd be extremely problematic.
So, Mr. Pell, when you use the terms bizarre and problematic, it just brings to mind, are you aware of any liberal democracies on the face of the planet that allow for an entrenchment clause? Because you brought up a lot of problems.
I'm not aware of any specifically. The thing I mentioned earlier was that Australia actually does have an entrenched piece of legislation on the books. It's called the Flags Act. It's the Flags Act of 1953 that entrenches the flag, the specific flag that Australia has. But it's widely known within the country and elsewhere that the entrenchment clause is not enforceable, and under the principle of parliamentary sovereignty, which is established by the Westminster system of government in the United Kingdom, the legislature remains sovereign over all previous pieces of legislature that it had passed. So in Australia, although an entrenched law is on the books, it's widely regarded that the parliament could simply overturn that piece of legislation.
Mr. Pell, if the validity of entrenchment clauses were to be upheld today by the judiciary, how do you think that would affect future legislation, if at all?
I mean, if you happen to have a group of people who are extremely concerned about their particular piece of legislation being overturned in the future, either by the same legislature or another, you could essentially have them. You could say that let's take the New York Times bill that we passed earlier, which was only set to last for 1 year. So you had a group of people who really thought this was a good idea and didn't want it to ever be repealed. They could say, the statute could never be repealed. And then if entrenchment statutes were allowed and that passed with a simple majority, then the statute could never be repealed. And that would certainly be problematic because then you would be binding the legislature, permanently. And new facts could arise, but that would maybe change the legislature's opinion.
All right.
So,
Mr. Pell, do you have any other relevant pieces of information you'd like to add to this process?
No, I mean, I just think that what's interesting about this case is there's no legal precedent, there's no statutory precedent, and there's nothing specific in the Constitution. So, in my opinion, our judgment should be based upon general legal norms, and also what would ensure a sound system of laws for DSG.
And in your opinion, if we allow an entrenchment clause to be valid and be used in future legislation, that would not create a sound.
That would be very problematic and would, could result in all sorts of legal quirks and problems in terms of funding in the future.
Well, thank you, Mr. Pell. No further questions from the respondents?
Your Honor, I ask that pending any cross-examination, Mr. Bell be allowed to step down.
Yes. You'll be granted time.
Thanks.
May it please the court. During Senator Curtis's speech, I wrote down a few things he said. I just kind of wanted to break those down one by one. But before I do that, I do want to speak to what Mr. Pell just informed you all of. Mr. Pell told you that there is no precedent judicial. There's no explicit mention of an entrenchment clause in our Constitution, in our bylaws. Right? An entrenchment clause, as we understand it, is a clause that limits how a statute may be repealed, how it may be voted on, how it is a limiting clause pertaining to a statute. That's the clause that was passed in the second statute concerning the PASH Reform Act. Right? The first statute granted $17,723, right around there, right? And that was a few weeks ago. At this last week's Duke Student Government Assembly of the Senate, 2 acts concerning the PASH, Peer Advocacy for Student Health, were passed. The entrenchment clause that's in contention is that was in the first one. First, I'd like to refer to Justice Bridges' question as to whether, or I believe it was Justice Bridges. No, it might have been Chief Justice Raphael, who asked about whether we were aware that we have the same entrenchment clause in our statute. We are absolutely aware, and we're not saying that ours should be enforced and that theirs shouldn't. We are saying that both of these clauses are unenforceable. That's why we're here today, because when this clause was called into question,
Are they unenforceable or are they unconstitutional?
unenforceable. So there's nothing in the Constitution that directly says that you can't have these words in a statute. You can put any words in a statute. Now, the question in today's case isn't whether they're unconstitutional, it's whether they should be enforced and can be enforced.
Well, so then, if what's in a statute can be selectively enforced, does that lead to a potential breakdown in rule of law, or does the judiciary become the sole body that determines what in various statutes becomes enforceable and what's unenforceable? I mean, who would then determine that? Would we have to review every statute and pick out certain lines that say, you know, this line's not enforceable, but this line is? I mean, I think that's getting into a slippery slope if we're talking about pieces that are passed that are not unconstitutional.
Yeah.
You're not claiming they are, but that are unenforceable.
I'll definitely get to that slippery slope, Your Honor, but to respond to your question, this, just because a clause, that's actually absolutely the duty of the judiciary. When any clause or piece of legislation in its entirety is called into question, the judiciary rules on that instance. In today's case, the instance is whether the entrenchment clause in the first of the 2 PASH bills passed at this last DSG meeting, the question today is whether that entrenchment clause is enforceable. Should they want to call into question the entrenchment clause in the next statute that was passed, that would be a different case, right? That doesn't mean that the judiciary has to go back and review every single piece of legislation ever passed, because not every single piece of legislation ever passed is being called into question.
Well, so, but the thing is, this does set a precedent, so that if the judiciary were to determine that entrenched clauses as you're currently defining them would be unenforceable, that doesn't just apply to the current statute at hand, that applies to your statute, it applies to every other statute that has any sort of entrenchment clause.
Absolutely, and it is our contention in today's case, as was expressed by the current policy advisor to the DSG's expert opinion. He testified that in his own, to his own knowledge, no other case has ever contained an entrenchment clause. To our own knowledge, to the respondent's own knowledge, no other case has ever contained an entrenchment clause, or sorry, no other statute has ever contained an entrenchment clause.
Other than yours.
Other than ours,
And
the other one. And as you heard after Senator Curtis's arguments, he didn't mention any other case that contained an entrenchment clause other than his own and ours.
Can you definitively say that there have been no other cases or pieces of legislation or statutes of any kind that contain any language that could be construed as an entrenchment clause?
To the breadth of my knowledge, there has never been an explicit entrenchment clause in any.
You reviewed every statute ever passed by Duke Student?
No, Your Honor. That's why I'm saying specifically to the breadth of my knowledge. It would take me years
Well,
and
so the
years.
judiciary can't rely on the breadth of your knowledge.
Absolutely
The judiciary
not.
needs to rely more on concrete fact unless we're provided a record of other cases, or other statutes that becomes very difficult.
Absolutely. What I can tell you definitively for a fact is that no entrenchment clause has ever been upheld in DSG's history and in the judiciary's history.
Well, it's never been challenged then.
It's never been upheld, it's never been ruled constitutional, it's never been ruled unconstitutional. It's never been ruled unenforceable or unenforceable. That's why we were referring to generally accepted law practices in every single governing body in the entire world, other than Australia, which has an entrenchment clause, or their flags, which is commonly known as non-enforceable. However, Your Honor, I'd like to get to the actual crux of our argument as to why an entrenchment clause is not enforceable, right? The governing piece of legislation that deals with how to pass a statute is seen in Title V of Section 6 of the Senate bylaws. This details how you're supposed to vote on it. It says that a statute is voted on and needs a simple majority to pass, right? This entrenchment clause would place an additional burden on how a statute must be passed, and in doing so would directly go against that Constitution. The Senate bylaws, right? The Senate bylaws do supersede any budgetary statute that's passed. Therefore, in order for this budgetary statute entrenchment clause to be enforced, you would have to enforce a budgetary statute over what the bylaws say.
Well, so where is the conflict between what the bylaw says and what the statute says?
The conflict is that it is in that there is a specific place allocated as to how voting may occur, right?
Well, it says by simple majority.
Absolutely.
But I don't quite see how this particular clause interferes with the simple majority, because another piece of legislation could be passed by simple majority to repeal that statute, and then another piece of legislation by simple majority could be passed to amend the budgetary statute.
Absolutely. What opposing counsel is saying is that because this entrapment clause exists, then we can't by a simple majority pass this statute that supersedes his own, which is not what's detailed in Title V, Section 6. Right. So, Your Honor, we are asking in today's case is strictly that you strike the entrenchment clause in his legislation. Should a case be brought about our own piece of legislation asking to strike the entrenchment clause, Your Honor, I would be arguing in favor of that, because I agree that that is also unenforceable. That my contention is not, I'm not asking you to enforce it in one case and not to enforce it on another case. We are acknowledging that in our piece of legislation, it does contain a clause that is unenforceable. However, that doesn't render the whole of the legislation as unconstitutional, because it is within the judiciary's abilities to strike a specific clause in any piece of legislation.
Are you saying it's unenforceable because it's in conflict with the Senate bylaws, or it's just unenforceable?
It's unenforceable. That's one of the reasons it's unenforceable. The other reason, and this is where I come back to the slippery slope that you mentioned, is that it does open that potential for a slippery slope. If I can then, within my own statute, include a clause that limits how it may be voted on in the future, I can include anything. I can include a clause that says it needs 75% of the vote. I can include a clause that says it needs 100% of the vote. I could include a clause that says it can only be overruled at 4:03 in the morning if a full moon is outside. And this would have to be voted on by the Senate. And if this clause is approved by a simple majority, then by the enforcement of the entrenchment clause, it would have to be enforced. So that's the scary precedent that's being set in today's case.
I don't think that anyone would say that if it included something that said, 4:03 in the morning at the night of full moon, and this can't be repealed, I don't think anyone would argue that that would be constitutional, because it takes away any opportunity for a simple majority.
It doesn't, Your Honor, because technically, the Senate could meet at 4:03 a.m. during a full moon. But I agree with you that it would be unreasonable and ridiculous. That's why I'm saying that it's so dangerous to approve this entrenchment clause and to enforce it, because you can draw that parallel, and it opens up that slippery slope. I'm wholly in agreement with you that it's absolutely ridiculous to add a clause that says that at 4:03 in the morning, when full moon is out, is the only time something can be repealed. But the same thing can be said about this. While this may not sound as ridiculous, it is possible to meet that insane clause, but nobody would do it, right? And thus you would have a statute on the books that is impossible, or at least nearly impossible, to repeal. Right? Furthermore, Your Honor, I
Good
would.
question.
Absolutely.
Why, I know specifically, we've been spending a lot of time talking about the entrenchment clause, but from your end, why specifically did you decide to create this piece of legislation as opposed to creating something that would try to repeal and then go through a different budgetary allocation?
That actually perfectly brings me to my next point, right? It's our contention that opposing counsel is presenting this lawsuit in bad faith. We understand the gravity of that allegation, which is why I'll further go ahead to explain it. We passed this because if you review the videos, which I'm sure many of you have, right, the past 3 DSG Senate meetings have taken no less than 6 hours. And the next couple are set to take the same amount of time, right? So instead of jumping through the hoops of passing not 1, not 2, but 3 separate pieces of legislation, going through the deliberations, having the Senate vote on it, to accomplish the same purpose, we included a clause that said that this goes to directly replace the previous budgetary statute. Now, Senator Curtis said, and I quote, that the bill has come into effect, right? He said that 5 days later the bill has come into effect. If we were to believe that, he might have something to go on. But the bill hasn't come into effect. The bill comes into effect 5 days after it was passed if the president has not vetoed it. But if you check your clocks, this bill hasn't come into effect. It's got at least another 3 or 4 hours. Now, I understand that that's a technicality, but I just want to tell you that you are not legally bound to go off of this clause because it hasn't come into effect.
Well, neither is yours, though.
Absolutely, it has not. That's correct. We are arguing as to the entrenchment clause not being able to be accepted. Furthermore, I'll go back to my bad faith argument, right? If opposing counsel wants to make the contention that the Senate didn't know what they were voting for in our case, right? That the Senate, because we didn't present one repealing it, and then present one replacing it, and then present one with the budgetary statute, if he wants to argue that the Senate didn't know, and if we'd followed the entrenchment clause, then they would have known what we were doing, and since we didn't follow it, the Senate was confused into voting for something, he can go ahead and make that case. We have a good faith belief that he will not make that case, and even if he tried, wouldn't be able to, right? Because the Senate knew exactly what it was doing. Therefore, by using a mere semantic discrepancy, Your Honors, opposing counsel is trying to thwart the explicit will of the Senate. Not once, but twice through roll call votes did the second passed reform bill pass. The first time, 19 to 18. The second time after a roll call vote, 19 to 17.
Objection, this is a misrepresentation.
Your Honors?
We have the report from Senator Hopkins,
Right,
which
right.
we review regarding the voting record.
If it's possible, I'd like to explain why I'm
You will have that
objecting.
time in your rebuttal.
Your Honors, if you would like me to direct you to the exact minute in the video where you can hand tally for yourselves the vote, I can do that at the conclusion of this time. Both times. There are 2 times. The first time, if you hand tally it, 19 to 18. The second time, 19 to
The
17.
vote really is
That's not in
relevant
dispute.
in the case.
Absolutely. So we're saying that this lawsuit, again, is being brought to circumvent the will of the Senate. The Senate voted to represent the student body, and when the Senate voted in favor of our
Well, you can
reform
make
bill.
the same argument that the Senate voted in favor of the prior piece of legislation.
Absolutely.
And therefore, not enforcing a section of it would be circumventing the will of the Senate.
Not, Your Honor. That's fine. That's absolutely right, but we're arguing that that clause is unenforceable.
But the first time, the Senate voted for this bill in its entirety, correct?
Absolutely. The
And
second
the
time
second-
and third time and fourth time, it was also voted in its entirety.
So, and when you proposed and had your piece of legislation passed that contained the entrenchment clause, did you consider having, like, why you were including an entrenchment clause if you felt that the first version was unconstitutional? Or is
Absolutely,
it
Your Honor.
that you felt this argument when there was a contest to your piece of legislation?
No, Your Honor. See, we didn't necessarily, the entrenchment clause hadn't been called into question at that time. We presented our piece of legislation in the way that we did because we simply wanted to change the allocation of funds. So we wanted to keep both pieces of legislation as similar as possible to the other legislation to make it easier for the members of the Senate, right? And we explained it that way. We said, this is our bill, we removed this clause, we changed up these 2 numbers. And that's how it was voted on after deliberations, after several minutes of questions, after a protective negative, after an affirmative speech. It was voted on and it passed. Therefore, by him bringing into question this entrenchment clause and asking us to, on that, not allow our statute, which was also voted on and which also passed, to be enacted, overriding his own, even though our statute contained language that said this goes to directly replace the previous statute, he's trying to circumvent the will of the Senate. I actually have a quote by one of the original presenters of his statute, who unfortunately can't testify in today's case, Senator Jackson Dillinger. I was on the phone with him and I was talking to him.
Objection, hearsay?
No, you can bring that up in your rebuttal.
Your Honor, I was on the phone with him, and we can, if we would like to have a subsequent hearing, have him in to testify, to say that he believes that this is, and I wrote it down on your legal pad.
You're welcome to show this to us, but because
Yeah,
he's
so,
not himself, we can't take it as.
absolutely, Your Honor, I simply just want to express what it was. I haven't had the opportunity to object either, and I would have objected to several of the statements he made as not accurate. But if I may quote, he said that he does not in approval of the way they are trying to pass this because he believes they are trying to pass their bill by, and I quote, less than legitimate means. These are words coming from the mouth of one of the original presenters of the bill, who spoke in the negative of our bill, and who spoke in the affirmative of their bill. He wants their bill, but he doesn't believe that this is being done through legitimate means.
Well, so, when you included your own sort of entrenchment, and I'm using quotations because I have my personal thoughts about the use of the word entrenchment clause on your legislation, did you, and you included the, it must be replaced by some, the sole purpose is to replace this piece of legislation. What was your intent in including that line?
Your Honor, to be quite frank, that was the intent in including that was to keep it as similar as possible to the original bill. Like I said earlier, this was something that merely, since our only dispute was the allocation of money and another clause that limited whether funds would ever be granted to the center again, right, which was in their original bill, which is not in ours, we just removed one clause and changed up a couple of the numbers so we could present it to the Senate as, look, this is almost exactly the same thing. We're not going to go through the whole document again. We're not going to explain to you every single last detail because everything else is the same except for these bits, right? And they all had the document. They read it themselves. They were all aware of what was in it. They all knew it contained the same entrenchment clause. Your Honor, our contention today is that no entrenchment clause, even our own, is enforceable. Whether our statute contains an entrenchment clause has no bearing in today's case, because today we are discussing strictly the entrenchment clause in his statute. Our statute can be presented and challenged in another case. And like I said before—
Well, your statute is the one being challenged, so both your entrenchment clause as well as the other entrenchment clause, or both of the clauses in question.
Okay, so I would say that any entrenchment clause is not enforceable, but not unconstitutional. There's nothing that explicitly states that you cannot have an entrenchment clause. However, it cannot be enforced because it leads to that slippery slope that I talked about before. In order to limit or somehow change how a piece of legislation may be voted on, whether that's originally voting for it, or repealing it, or replacing it, there has to be a bylaw or constitutional change. And that requires a 2/3 majority.
Right, but I struggle with this idea of unconstitutional versus unenforceable. And if it were explicitly unconstitutional, then of course we would rule that it was unconstitutional. But because it doesn't say that, and that you're claiming it's simply unenforceable, then I think we get into the slippery slope of the judiciary becoming legislating branch, and that when clauses are brought to us of this isn't enforceable for whatever reason, this isn't enforceable because of this reason, or the president is refusing to enforce this clause, therefore it's unenforceable, and we're the ones deciding that, we're effectively becoming a legislative branch.
Your Honor, if it's the desire of the court to rule this clause specifically as unconstitutional and to strike it from the legislation, we are more than happy to accept that. We just want to stress the point that just because a clause is unconstitutional doesn't render the whole of the legislation unconstitutional. It is well within the abilities and within the power of the judiciary to strike any single clause from a piece of legislation.
Right.
Yes, so if you would like to rule the entrenchment clause as unconstitutional, by all means, Your Honor. We'll delete it from ours, we'll delete it from theirs. But what that means is that their legislation can't prevent ours from
Well, I
passing,
don't think anyone's contesting that.
whether their legislation.
That if that clause were to be stricken, then I don't think anyone would be contesting that yours would supersede the previous.
Absolutely, Your Honor, absolutely. So if you would prefer that it be stricken, we can change our plea to ask that the entrenchment clause in its entirety be stricken.
We'll discuss and consider that.
Certainly, Your Honor.
You have 1 minute left.
So, in summation, what I'd like to express is that, again, not only is the entrenchment clause unenforceable and unconstitutional by the definition of Your Honors, and therefore it wouldn't allow them to keep our legislation from passing. But this lawsuit in itself isn't about upholding the entrenchment clause. It's about them trying to get their own means to an end through backdoor means, right? They're trying to pass their legislation and circumvent the will of the Senate, which voted on another piece of legislation after theirs was presented. Senate voted on their legislation, then after another piece was presented, voted to uphold a different one, and voted to directly replace the previous legislation. And they're trying to get around that by using semantic discrepancies.
That's time, thank you. Mr. Pell, if you would return to the witness stand, I will grant time for the petitioner to ask some questions if he so chooses.
Thank you very much, Your Honor.
Do you want to ask some questions?
Yes. How much time for this?
5 minutes.
5 minutes. Okay. Is this included in the rebuttal?
No.
Okay. All right, so I just have a couple questions here. Mr. Pell, in the Senate bylaws and Constitution, is there a portion that says that Senate must approve statutes by 50% majority? Is that that's in Constitution and bylaws?
Yeah, the Constitution says that the Senate can pass a statute with a 50% majority.
Okay. Does it say anywhere that the Senate cannot make an entrenchment clause?
No, it doesn't specifically say the Senate can't make an entrenchment clause, but it's
All
my
right.
belief that, if
So,
the
okay,
clause that I'm answering a question, if it says that it's allowed to pass a statute with a 50% majority, in my opinion, and the Supreme Court essentially made the same argument in their case, based upon a similar constitutional structure, that the power to enact a statute with 50%
Right.
therefore prohibits
So,
implicitly entrenchment clauses, because an entrenchment clause limits the ability of the Senate to pass
okay.
a law with a 50% majority.
Yes. So, do the bylaws or Constitution say that the Senate may make previous statutes disappear just by virtue of passing a new one? Is there any line in the Constitution or bylaws that say that?
Well, I mean, that would be an extremely specific thing to include in the Constitution, but again, as I said, the fact that it says that the Senate can
So-
pass a statute with a 50% majority
There's
means
no-
that it can pass any statute.
There's no principle of
overriding
supersession.
any
There's
statute with a
no
50%
principle of
majority.
supersession in the Constitution or bylaws, correct?
No, but it's clear that, I mean, the
Right.
Senate passes laws all the time that replace
So-
previous statutes. It's a norm.
So
It would be very bizarre.
So the Senate can use its 50% sovereignty, or it can use its sovereignty to pass statutes with a 50% majority as long as those statutes are within the bounds of bylaws and Constitution, correct?
They can pass laws with a 50% majority about
Right.
whatever they
So-
want, as long as they're not unconstitutional.
Right.
But
Thank
that
you.
doesn't. and-
So,
yeah.
so would you say that there's a fundamental difference between creating a clause that raises the threshold of percentage for voting on a statute, that's fundamentally different from something that has no constitutional or bylaw prohibition?
It's different. Can you repeat the question? I'm sorry.
So would you say that there's a difference between a clause that raises the threshold for future statutes in terms of percentage, and there's a difference between that and some other clause regarding,
Entrenchment?
entrenchment?
So the difference is in the difficulty of the repeal, but not in the principle of the entrenchment in making it more difficult to repeal.
Right. So, let's see. So just to clarify, as long as a statute doesn't breach any constitutional or bylaw provisions, you would say that because of parliamentary sovereignty, or would you say that because of parliamentary sovereignty, that should be enforced?
Yes, but the principle of parliamentary sovereignty dictates very specifically that the parliament can change any of the previous statutes that it enacted. That's essential.
Where in DSG's own legal documents, in its own, any of that, where does it say that there is, like, okay,
That's not
yeah.
documents in front of them.
Yeah, but
So I
again,
was just looking at the
I
documents.
think the question is essentially, where does that concept derive from? I would argue that it very strongly derives from the fact that,
Right.
that the Senate is allowed to pass laws
So-
with a 50% majority. And something that that makes it more difficult to pass a law, something that prevents the Senate from passing a law with a 50% majority,
So,
you know, even if the entrenchment clause at a specific time,
Right.
that would then, you know, not be allowed, because it violates that principle of a simple majority ruling, regardless of, you know, previous statutes on the books.
okay, thank you. That's all I'm gonna ask from our witness here.
You have approximately 4 minutes.
Okay, cool.
You do not need to take up that time.
All right, so I'd like to take out a few points from the testimony by Michael Pell, the cross-examination, that we have some fundamentally important properties to discuss today. We have parliamentary sovereignty, and we have that because of that parliamentary sovereignty, the Senate can create statutes that are enforceable insofar as they do not breach bylaws and constitution. And I want to highlight out of this the principle of supersession. The principle of supersession exists because of a creative use of language within statutes, namely the lines that all, that to the extent possible under the Constitution and bylaws, all laws and regulations in conflict with the statute are hereby declared null and void. That is supersession. The only reason it exists is because somebody decided that they would word the end of their legislation that way. As the witness, Mr. Pell, brought up, there's nothing in the Constitution or bylaws or House rules that establishes a principle of supersession. The only reason that exists is because parliamentary sovereignty says one thing that the Senate passes that has full enforcement or enforceability, namely establishing that all previous stuff is null and void, can be done. And we're arguing today that in a similar fashion, a clause that says that as long as, a clause that says there's a specific way that you have to repeal this legislation, as long as that method doesn't conflict with any superior rules, such as bylaws or constitutionality, which the respondents today have pretty much acknowledged, and that the witness, Michael Pell, has acknowledged, there's no constitutional or bylaw prohibition against entrenchment. Because of parliamentary sovereignty, that line must carry just as much weight as any supersession. So the argument that we're bringing up today is really about parliamentary sovereignty. Does the Senate have the ability to enforce statutes that it passes because solely on the nature that there's that the Senate decided to vote for that? And what we on the petitioning side would like to argue is yes. This policy tool, the creative policy tool for entrenchment, doesn't allow the percentage threshold on votes to be raised because there are constitutional and bylaw rules on that would conflict with. It doesn't allow for it to be only passed at 4:03 in the morning because there are constitutional and bylaw rules saying that any Senate meeting is where statutes and legislation can be passed. So it would conflict with those rules to say you can only do it at this time. As has been mentioned time and time again in this hearing, there are no rules in any superior guiding documents for DSG above statutes themselves that say entrenchment is illegal or unenforceable. Thus, just like supersession is a creative policy tool that was created by somebody deciding to write it at the end of a document, entrenchment that doesn't conflict with any constitutional bylaw, House rules, or Robert's Rules of Order should similarly be accepted. Just to do a final rebuttal of some of the points made by the respondents, they seem to be trying to give the impression that I was arguing that the Senate was confused. I never was arguing that. I was trying to preempt an argument that they would make that was that. I'm glad that they did not. So I think we can all agree that that the Senate established two. I guess what we have here is the response of agree that the Senate used its sovereignty to establish two pieces of good law. The one with the entrenchment clause will be good law. I'll accept that it is not necessarily. They will both become good law in a few hours, but the one with the entrenchment clause first, and I might add with a higher vote margin. So that if we accept the parliamentary sovereignty argument, that, because it doesn't conflict with any higher rules, just like supersession doesn't, must be taken as good law, and thus allowing a new statute to completely ignore the old one creates a conflict that requires the UCAE and other funding departments within DSG to selectively enforce those statutes as to whether or not it requires it. It requires them to decide whether the ban should stand or whether the new budget allocation should stand. So, as I think Chief Justice Raphael, right, brought up, I think it's dangerous to have selective enforcement by any body of DSG that isn't judiciary making an explicit case decision. And I want to bring up again this argument of circumventing Senate sovereignty, that either decision would overturn one of the would necessarily overturn Senate's will on one of the pieces of legislation. And that is pretty much how all judiciary cases work. That one could argue that they all circumvent legislative sovereignty or legislative decisions or executive decisions because they have the power and are supposed to have the power to actually reverse decisions that are, or to reverse bad decisions. And that's what we're arguing today. That enforcement of the latter legislation that was passed later and therefore comes into law later requires selective enforcement and requires that DSG create a precedent for ignoring pieces of good law. And because we think both of these are horrible precedents for DSG to stand, especially in a time where DSG is trying to institutionalize all of its organizations and documents and operations, increasingly so, we on the petition side think this would be a horrible precedent to send to the school and to the DSG. Thank you.
Great. So with that, Wiseman et al., the Brunetti et al. Has concluded. The next case will be at 9 p.m., but please clear the courtroom until that time. Thank you very much.
Well, good for me.
You're barely in the frame.
What?
I mean, that way is
My name is first.
Pardon?
I mean, I will just say, it seems like a lot of men trying to silence a woman of color.
Saying that for any legislation
Like, it's very hard
for something not that he says or
it's very hard
is
to
not
I think that should be the first.
It's
what I'm
mostly a
reading
function of the syllables and the range of
And
the case.
did the Chief Justice agree with that?
The request was convincing.
This is on video.
If you would like to file a counter request, we can consider it, but I would urge the petitioners
You're
to
gonna.
focus instead on just verifying through and you're just
Everyone will be like,
I don't think you understand.
this
the
one video. Damning.
That is your favorite
Yes.
song.
You're
There's
Joe
a reason
Biden.
for John Guarco that song.
I know, yeah. Plot twist of the century is me and John Guarco agreeing.
Right?
I've never been
Oh,
to
yeah.
And it turns out we're both self-centered.
Just
No,
like
I
it might be
have a
on
notebook.
The court is called to order. We are now hearing the next case, Lockhead and Guarco v. Mecklai. We will go ahead and introduce ourselves, and then I will go briefly over the rules and procedures of this case.
Good evening, I'm Justice Annalise Bridges.
Hi, I'm Justice Stephen Rothfuss.
Chief Justice Dana Raphael.
I'm Justice Andrew DeStelle.
Associate Chief Justice Ross Woodson.
Great. So each side will be granted 30 minutes to make their argument.
Wait.
Oh, my apologies. We have a justice Skyping in from abroad, and we skipped over him. Go ahead.
Justice Abdi calling in from the wonderful city of Paris.
Yes, so he is here with us as well this evening. So each side will be granted 30 minutes, beginning with petitioners. There will then be the respondents will then be granted 30 minutes, and then the petitioners have 5 minutes to rebut anything said in the petitioner's arguments. I would remind both sides that they are not required to take the full 30 minutes. That is just the time that they've been allotted. And I would also like to remind the petitioners and respondents that this is not a trial case. You may not interrupt and say, I object, or anything like that. If you do have objections or issues with what the other side has said, please respectfully wait until your time has been allotted, and then you are more than welcome to make your objections clear then. So with that, we will, yes,
Brief question. So the
Yes.
5 minutes for rebuttal, does that come out of the 30 minutes originally
No.
allocated?
you have an additional 5 minutes, yes. Great, so with that, the petitioners have 30 minutes, starting now.
Sweet. Do I go to the full thing?
You are welcome to sit there, you're welcome to go to the podium, whatever works for you.
Yeah. These things. So, okay.
So basically there's three kind of main questions that we want the court to decide on today. The first is whether or not the DSG president actually has line item veto authority vested by the Constitution. The second is what constitutes sufficient rationale for a presidential veto, and whether or not, if that rationale is sufficient, that then invalidates the veto itself. And then third is to clarify the process by which the annual budget would be resolved if it does end up getting vetoed. So we would argue that, so we're going to go sequentially, but first we're going to discuss the rationale argument and why we believe that a rationale is necessary for a veto to hold and what characteristics that rationale must meet. Secondly, why we believe the president does not have a line item veto, which Guarco is going to discuss. And then lastly, what law in the Constitution we believe governs the process by which the annual budget becomes resolved if there actually is a veto. So first let's talk about the rationale. So Section 5, Clause 3.
Sorry, Justice Debaki has a question.
Sure.
Hi, just a quick question. So in the petition that you guys filed, you guys referenced the veto letter. However, in the total case documents that we received, we got a veto letter that was a lot more extensive. So I was just wondering if you guys also had received a copy of that. And when you talk about, because you're bringing up the sufficiency of the presidential veto, are you referring to the original, like, very short letters or the very long, extensive veto letter that we now have?
Sure. So we did receive the long form letter that had a justification that we believe is sufficient. So our question is not whether the long form letter is valid on the grounds that there was not actually a rationale, but rather that in the future, if there is not a rationale submitted, that then invalidates the veto. So it's not consequential for this case because what we believe to be sufficient rationale was offered, but in the future, that's something that the court should decide. So we did get that letter. So this is just for the sort of sake of argument, and I'm going to go fast so we can get to the most important question, which is whether the line item is actually implied. So Section 5, Clause 3 of the Constitution states that the president, quote, the president shall veto the act by notifying the executive vice president of the veto and of the president's specific objections, and the act shall not take effect unless subsequently passed by 2/3 vote of the Senate to override the veto. So the reason why there must be a rationale that's submitted is because the Senate has to have an understanding of effectively what they would have to change about the law for it to be approved by the president. In other words, there's a reason why this clause is instituted, and it's because there has to be a credible commitment by the president to something that she specifically finds objectionable within the legislation. So imagine a world in which if there's no rationale submitted, the president just vetoes the thing, it goes back to Senate, there's not a 2/3 override, and the Senate goes, okay, what are we going to have to do to get the president to agree with it? There has to be, again, some basis upon which they're reconsidering the legislation.
So are you arguing that the veto is not valid because at the time the veto was issued, it did not contain?
Sure. So the first veto that was issued to us did not have a rationale. We argue that that is invalid because it did not have the rationale and therefore does not meet Section 5, Clause 3 of the Constitution. We are not contesting the validity of the subsequent veto, which we believe President Mecklai had the authority to issue.
Well, then isn't the first veto really irrelevant then if the second veto stands?
Sure. In practice, it's irrelevant, right? Like it's not consequential for Chanticleer funding, but we believe that it's...
So let's focus on what pertains specifically to this case.
Yeah, well, since that issue is not at the crux of this case, the judiciary will likely not consider it. You're welcome to make that argument.
Cool. Yeah, so I'll make it quickly because I think it should be addressed, and then we'll spend the rest of the time going through the line item veto. We'll take 2 minutes. So first is, if the argument is, well, there was a rationale submitted to somebody via word of mouth, and that should suffice, I would argue that that is clearly insufficient in terms of how the Senate then proceeds to make a decision in light of the veto. And then if the argument then is, well, if we assume that something like a small side conversation isn't sufficient, then doing something like Keizra Mecklai did, which was to give quotes to the Chronicle that then signify why the veto is valid, we believe that there's no legal distinction between those two things, and so therefore it must be an officially submitted rationale to the rest of the Senate, and that's the only grounds upon which the veto should be considered. So we think that's important to be addressed now, so we don't have to do this again, and also because it was consequential in terms of the first veto that was issued. But now we're going to talk about the line item veto, and why we don't believe that that power is implicit, and then continue finally to the annual budget. And as a point of clarification, there were 2 statutes that were vetoed in this case, one of which was a surplus statute, which did not pertain to annual budget. That's not a question. It's only the annual budget statute for the Chanticleer.
Wait, so it was the, if I understand correctly, and please correct me if I'm wrong, I just want to state this for all participants and for the record. There was first a statute passed for the Chanticleer funding that funded $20,000, or the amount of money is irrelevant, but
Sure.
funded the Chanticleer some amount of money, correct?
Correct.
And that passed.
There were two funding allocation votes, the first of which was an amendment to the annual budget, which was for
I
$20,000,
was speaking about this
which we're gonna,
easily too.
and that was the subject of the line item. The second was a budgetary statute that was an independent, thing that the Senate considered, an independent piece of legislation that was not under annual budget, that was vetoed by President Keizra Mecklai. That veto is not in question, because it was not a line item, it was vetoed as a line.
Members of the judiciary, tonight I'll be speaking predominantly about the line item veto and the lawlessness of it. First and foremost, let's talk about what the initial vote was. We spoke about the Chanticleer annual budget component of the entirety of the annual budget. As noted by Section 4 of the Student Organization Finance Bylaw, the SOC shall solicit applications for annual budget allocations from chartered groups. The Chanticleer is a chartered group. Furthermore, after there's a motion made, and which was seconded and subsequently voted on, which would bring about an amendment to the annual budget component of the Chanticleer. It was an amendment to fund $20,000 additional for the yearbook, and it was in order because the senator can do that as per Section 8 of the SOF bylaw. Moreover, I, as the executive vice president and as the president of the Senate, have the power to break a tie, which is what I did as per Title 2, Section 2, Clause D of the Senate bylaw. Voting on legislation to break a tie, if the executive vice president has decided to break a vote, it was announced at that time to the Senate they had done so. I did, and I voted in the affirmative. Now, afterwards, we voted on the entirety of the Chanticleer budget, passed it, and then we moved on to a budgetary statute after a motion was made, seconded, and voted in the affirmative, which we passed again, with a higher margin than the previous two pieces of legislation. Now let me explain why specifically we keep line item veto is not granted per the Duke Student Government Constitution. Regards to first and foremost veto, Section 4, Clause 8 of the Constitution says the President shall have the power to veto acts of the Senate within 5 days of passage. And whereas SOF bylaw Section 11 regards to presidential veto power states, except as provided in Section 10 of this title, the President's power to approve or veto the annual budget shall be the same as for any other act of legislation. Now, we anticipate the opposition will say that the annual budget should be treated as any other form of legislation. However, there is no line item veto for other acts of legislation. In the same way, you cannot strike a section of a budgetary statute or a part of a resolution, you cannot strike a component of the entirety of the annual budget. Lastly, while we understand that, as was mentioned in the case before, that the Duke Student Government is not an exact replication of the American government, it is still modeled after it, which is why we believe that Clinton versus the City of New York, regards to specifically line item vetoes, is valid and important here. The court issued a majority opinion that the line item veto is unconstitutional, and that it violates the presentment clause of the American Constitution as per Article 1, Section 7, Clauses 2 and 3.
Were you able to find any case precedent of DSG law that referred to line item veto?
No, this is, I believe, the first of its kind. However, like I mentioned before, we are modeled after the American government, and the presentment clause can be from, the presentment clause is imbued within the Duke Student Government Constitution as per Article 4, Section 5, which deals with the passage and vetoing of legislation for the Senate and the Duke Student Government President. And the presentment clause of the United States Constitution outlines federal legislative procedure by which bills originating in Congress becomes federal law in the United States, in the same vein as the Constitution outlines the procedures for Senate law becoming the law via the President's approval or disapproval. In the majority opinion issued by Justice John Paul Stevens, he noted 3 reasons why the cancellation power was different and which is why it violated the presentment clause. And I will read it verbatim. First, while the return of a bill takes place before the bill becomes a law, under the line item veto act, the President could cancel the bill within 5 days after it had become a law, which I may note is similar to our Duke Student Government Constitution, in the sense that the President has 5 days to veto a bill. Second, the return of the bill rejects the legislation in its entirety, while the line item veto act authorizes the president to cancel portions of a bill. Regards to line item veto act that President Wilkins uses as justification for its line item.
You do recognize that the DSG system, while modeled after the American system, is not directly guided by.
Right, we do realize that, but we feel it is relevant to this case.
Okay.
And finally, one more last point, the Constitution is silent on unilateral presidential action that either repeals or amends parts of duly enacted statutes, which deals directly to the points we made earlier in regards to the lack of the president's power to issue a line item veto of any part of the annual budget, and same as the president does not have the power to strike a section of legislative statute or resolution. And I will now.
So I'll finish this up. Again, the point of the presentment clause, the logic is that when the Senate votes on a piece of legislation, they vote on a certain piece of legislation that then goes to the president, and the president can approve or deny the same piece of legislation. The president, by issuing a line item veto, effectively changes what the legislation is, so it implies that the Senate supports the final legislation, which is not the case. The majority of Senate might not believe that the budget that President Mecklai, with the line item passed, would have been supported by the Senate, i.e. a senator who votes for the whole thing with the Chanticleer, and then a president who changes what that legislation is. You cannot assume that those two pieces of legislation would have been agreed to by the Senate in the first place. So that's why the president, the House, the Senate all have to pass the same thing. So that's the point, right? Second, and I'll reiterate, is that she has veto power for the annual budget in the same way that she has veto power for any other act of legislation. And again, she can't line item a statute. She can't say, oh, well, this statute is funding 30 grand, half of it is for sex toys, hypothetically. I don't like that, let me take out the sex toys. You probably heard this before, right? Like, that's something that I don't like. I'm gonna line item veto this and pass the remainder of the statute. That's not a power she has for a regular statute. It's not a power she has for the annual budget. Again, because the annual budget is voted on as a whole. You take a yes/no vote on the entirety of the annual budget, and that's why it's the same thing. So now I want to talk about the actual annual budget process. There's actually no regulations about what happens if the actual thing doesn't get passed at all. So
The whole thing?
right. So let me explain really briefly kind of what the situation is. So if the annual budget is vetoed, the presumption is that it would just get considered again. Obviously, we're leaving school and we have 1 week left. The problem is that the Constitution mandates that there has to be a 5-day period between a first and a second reading of the annual budget. So if President Mecklai vetoes the entirety of the annual budget, presumably it would return to a first reading. And then there would have to be a 5-day period, and then we'd have to vote again on the annual budget. In other words, let's pretend so the important thing is that the annual budget, in that there's 2 readings, is similar to bylaw changes, and that bylaw changes also have 2 readings. When you present a bylaw change, you present the first reading, read to Senate. The second reading is when you have the vote. If during the second reading the Senate votes it down, it cannot then be reintroduced the following week and voted up or down again. Rather, it reverts back to a first reading because the legislation is dead, right? Legislation does not just stay alive after the Senate votes it down. It has to be reintroduced anew. So the reason why this is relevant is that if President Mecklai vetoes the annual budget in its entirety, which we believe she completely has the right to do, we just argue she doesn't have the right to a line item. If she vetoes the entirety of the annual budget is dead, and it must be presented in the same way as a bylaw for a first reading this upcoming Senate. The issue is that we're leaving and we don't have a second Senate meeting 5 days after that first reading, in which case there's no way that DSG can actually approve an annual budget. So, secondly, I direct your attention to Section 8 of the SOF bylaw, which states that the final annual budget may also be passed by a majority vote, but not earlier than 5 days after a first reading of the annual budget before Senate. The key word here is may. There is nowhere in the Constitution that states that an annual budget shall be passed, rather that it may be passed by a majority vote. So there's no world in which the Senate must pass an annual budget. But here's the really critical thing, right, is does that mean that the annual budget stays alive after it was voted down during the second reading? And we argue no, because not only does it mirror the same thing as bylaws, where it's just straight up dead after the first vote, but it says that but it says that the final annual budget may also be passed by a majority vote, but not earlier than 5 days after a reading of the annual budget. So in other words, it's not 5 days after the reading of an annual budget, it's the same annual budget. And the reason this is important is because during the second reading, we made amendments to the budget. So if it's proposed again, it's not the same annual budget. For example, we funded an additional, whatever, like 10 or 15 grand to some religious life groups, so it's a different annual budget that we voted down on. So it's introduced again, entirely different piece of legislation. And again, the wording of the SOF bylaw suggests that it is the annual budget, the same annual budget, not an annual budget in general. So then the question, yeah, go for it.
So I'm confused, so the judiciary can't particularly rule on the possibility of future cases?
Sure. So, right, so the implication then is what happens if the annual budget is presumably completely vetoed, right? So let's assume that President Mecklai decides she's going to veto the whole thing, right? The whole thing dies. It is then not eligible to be brought up, according to our interpretation of the Constitution, next week for a final vote. Therefore, the budget goes away. And the section of the bylaw that governs sort of like what happens in response to that only states that the president may change the budget if it affects or is related to a mandatory expenditure by the university or that's contractually obligated. So in other words, if the university says, we have to fund the Chanticleer because we have a contract and it's mandated that we fund the Chanticleer, and then the annual budget is vetoed, for example, and the annual budget goes away, then it is President Mecklai's prerogative to decide with the SOFC chair to fund the Chanticleer up to whatever was mandated. Obviously, the Chanticleer is not under a university mandate. Obviously, there's no mandatory contract.
And the university mandate, so it would be that Senate could pass an annual budget, and then the university could say you must fund X, Y, Z, and that could be added in after it was passed?
So not exactly. So basically, let's say that what the Senate allocates is insufficient for the university's funding mandate. If that's the case, let's say that we have to pay fire insurance for the DSG office, right? And every year, the DSG Senate allocates money to pay for fire insurance, and that's like state law or something, right? Then the university says you have to pay fire insurance. Let's pretend we go to the Senate, and Senate says, JK, we don't want to fund this, doesn't fund any fire insurance money, and then the university's like, you can't do that. Then it would be President Mecklai's prerogative, because it's mandated by the university that be funded, that she can amend with the SOFC chair the annual budget. This is not the case with the Chanticleer.
So that's the only time that she could...
Correct.
Okay.
And that is in
Section 10.
Section 10, yeah, of the SOF bylaw. And I'll also state that the argument that we're making that a bylaw change with the 2 readings, after the second reading it's voted down, is just straight up dead, is because it's analogous to the bylaws. So there's 2 votes on the budget.
Excuse me, Deb has a question.
Yeah, go for it.
Deb?
So, if, for example, like in the case where the university mandates funding, that would be the president adding in that in here, but I do see, right now, I do see a distinction between, the president putting in whatever, she wanted to into the budget versus exercising a veto to remove something, the
Sure.
difference here, the key difference for me here is that instead of having the power to do
Right.
an amendment or to add something, she does have an express power in the Constitution to remove, or to
Right.
maintain the status quo
Well,
of the law. So,
Well, no, they don't have an express line item to remove, only to maintain the status quo insofar as it's mandated by the university or a legal contract. And I think that's a useful distinction, because if President Mecklai had the authority to sort of put in the status quo afterwards because she believed that was the right thing to do, then that's effectively the same as the Chanticleer, right? Where last year it was funded 0, this year it's being funded presumably some by annual budget. If the budget, for example, overrides her veto, then she should not be able to go to the SOFC chair and say, hey, under the status quo, we believe that the Chanticleer should be funded 0, therefore we're going to fund 0. The distinction is that the only world in which she can do that is when it's mandated university expenditure. The reason why we're bringing this up, right, is not because it actually pertains to whether or not she has line item veto authority, but rather the presumption is that because she's already issued a veto for the entirety of the annual budget on the contingency that this case does not rule in her
Wait,
favor,
she did
then
so she vetoed the entire annual budget.
sure.
So
Not a fit. So I don't know how this works because this isn't real life, but well, it's kind of real life. But like basically, the presumption is if the court rules against President Mecklai, she has indicated she will veto the entirety of the annual budget.
But she
obviously,
has
that
not-
would be
but-
she has not done so yet. So it's a separate suit. So the question is, why are we talking about this?
Yeah,
Right?
it has been issued.
The veto for the entire annual budget.
Yes.
Out of your opinion.
Annalise, can you grab that?
Okay, so, okay, great. So then the argument is like, then why are we even talking about her authority to veto a line item if she's vetoed the entirety of the annual budget? And I would argue, one is that she did this presumably not because this was what she wanted to do, but rather in anticipation for what the outcome of this case would be. And two is that you should rule on the legality of the line item veto in and of itself, assuming that that might not like hold, or she might renege, or like whatever. So the point is like,
Well, so why should we rule on the line item? I mean, this veto supersedes any previous veto, so why should we consider the line item veto if this supersedes it?
sure, so if that's the case, then like, maybe this entire question before you is null. I would argue that the reason, so then like, it doesn't matter and you guys don't make a ruling and like, we'll just leave and it'll be chill. The reason why like, I would argue that it's important that we had this in the first place and that it wasn't a waste of time was because it was her complete intention to issue a line item veto, recognized that it was not constitutionally protected, recognized that she would fail this argument in court today, and then would not be able to veto the budget as a whole. So it's kind of
Why
like,
would she not be able to veto the budget?
because if the ruling didn't come out in time, or you know, if something weird happened, so she's basically saying, just kidding, I think I'm gonna lose the case, let's go to court, see what happens, I'm just gonna sign the veto of the entire thing because I realize I don't have this power, and so like, let's just not make a mistake, right? So she's avoiding the worst case scenario, which is that her line item veto gets overturned,
Wait,
and
this is
then-
a hypothesized plan? Or?
Sure, so
Okay,
what I'm
that's
saying is
right.
that if it's true that like, because she's vetoed the whole thing, then the question is null and void, then like, I take that point and like, we can all just leave and it doesn't matter. So now my only argument is like, that might be true, but I'm sort of describing why it's still important that we had this court case. Because if we didn't have the court case, she would not, or didn't threaten to have the court case, or she didn't realize that she would lose in court, regardless of whether or not you issue an actual ruling, then she would have only done a line item veto.
Simultaneously, there's still the question of what we should do if the veto of the entirety of the annual budget goes into effect. Is this first reading it again, in which case we wouldn't be able to actually vote on it after, and as well as the legal precedent for any DSG president in the future who may decide to issue a line item veto.
So I would say like, obviously, if she's gonna veto the whole thing, then we're done here. What I would say is, please don't be like, okay, she vetoed the whole thing, let's just not make a ruling because we don't have to. Like, just because, I mean, like, let's just talk like in real life right now, is that like, this stuff never really happens, and I think it's important for future DSG presidents to understand what powers they do or don't have, so that like, if they exercise a line item veto and nobody cares about it and doesn't think about it because it's student government and like we're Duke and her lives, then like, it won't be brought up, and then like, there will be no rule of law. So obviously that's incredibly hypothetical, but like, I'm arguing just like for the sake of DSG and like for the sake of in practice what it means to like make a ruling. Obviously you don't have to, but that would be it. Does that make sense? Why it's important? Cool. But maybe we're done. I think we're probably done. Cool. Any questions?
Great.
I don't believe so.
You have essentially 4 minutes remaining, so you may add that to your rebuttal time if you wish.
Okay.
You are also not required to take that time, but with that, the response will be granted 30 minutes to respond. You are not required to take your entire 30 minutes, but you do have that time available to you.
Okay. So I'll say a couple of things. First is with regard to that last point about vetoing the entire annual budget. That was sort of a provisional, decision. The idea here is that we want to be as responsible as possible, and it's sort of a last resort, worst case scenario where we have to veto the entire annual budget, because like Tanner just said, that does kind of go into this gray area, and then we open up a lot of questions. So from a legal standpoint, we're trying to be as responsible as possible, but also ensuring that we're responsible with our money. So it is kind of this double standard thing. But if you have any questions, you can ask me to clarify that later, or see if what I have to say kind of does it as I go along. So the first thing I'll say is we're not saying that she has the right to a line item veto. We fully agree that she doesn't have the right to a line item veto. And EVP Guarco was right in using national precedent as the example. Clinton v. City of New York is very clear that without an explicit statement in the presentment clause, it's basically equivalent to an express prohibition of the line item veto. So we're not claiming that she has the line item veto. We would actually ask that in your ruling, you do affirm that she doesn't have the line item veto, because I think it's important kind of going forward.
So there's no contestation that the president does not have the right to a line item veto?
Correct.
And you do wish that that be codified in some sort of judiciary decision?
Yeah, because I think it is important, and
Well, if you all agree on that, then why would it not be?
Yeah, I have a different rationale for why the veto is valid, which I'll get to in a second. It's a definitional issue, but.
Well, so you'll explain why the Senate shouldn't just take this question up themselves and, codify the president's not a right to line veto. Why are you asking us to decide that question?
Because it was brought up in the petition.
Well, but the question is no longer relevant if the veto has been overturned by.
It doesn't really matter. I just think, in this particular case, it actually was decided by a court.
Okay.
But
You make.
maybe let me rephrase that. I think it's important. It would be valuable for you to note that without an explicit line item veto, she doesn't have it. Does that make sense? Sure, the Senate can take it up and say whether or not she does, but I think from a judicial standpoint, we are operating off national precedent to a certain extent, and I think in this case, it's important just to note for future DSG presidents.
So in admitting that, you're now about to defend the veto still?
Yes.
The line item or the one that we were.
The so-called line item, but it's not actually a line item. Let me go through it, and then if you guys have any questions, you can ask.
So you're saying that it's not, you're going to make it clear it's not.
So you're saying it's not a line item?
Correct.
All right.
And I would
That's fair.
have sent y'all an explanation, but we had like 12 hours to do this. And
That's fine.
All right, please continue.
Okay.
I really need to shower.
Please continue.
I did take a shower today, so we're good. So at heart of this particular case is a definition of what exactly the annual budget is. So this kind of is the heart of the judicial question that we're asking you guys to rule on. We see two different possible definitions for what the annual budget is. We have an opinion, and I think the opposition would have a different opinion, so I can try to explain both sides, and they can say whether or not they agree with that when they do the rebuttal. So the first would be a kind of conglomerate or omnibus definition, where we see the annual budget as a conglomeration of smaller budgets of each individual group, right? So there are three reasons why this is the definition that we think should be most relevant. The first is that the Senate votes on each particular group as we go through it. There actually is a first and a second reading to every single group. So when we do annual budget, you guys know we stay in that room until last week it was 2:15 in the morning. And the reason it takes so long is because we go through there are like 120 groups basically, and we sit there and we read off the budget for each group. And then when we have a second reading, the Senate votes on every single group, yay or nay. So they're treating it as if it was an actual budgetary statute, approving the budget of each individual group. So we vote 120 some odd times on the budget for every single group. So I think that's important for our definition of a conglomeration of individual budgets. If you want to get specific, they're individual budgetary statutes approving the budget requests of each group. The second reason we support the omnibus definition is that, as I can't remember who mentioned it, but SOF bylaw Title IX, Section 8 says the final annual budget may also be passed by a majority vote. That doesn't require that it's passed by a majority vote.
So what would happen if it were not?
If it were not, nothing would change, basically, right?
You mean nothing would change?
Each group would still get the funding
So-
because it's voted on.
So as I understand, so it's, let's say there are 120 groups, and you vote for each group on their individual budget, first and second reading, and then you pass a separate separate statute, separate piece of legislation for each of those groups.
Correct.
And you're arguing that what we're referring to as the annual budget is just a conglomeration of all of those, it's like a summary of all of those statutes.
Correct.
Okay. And if that budget were not to pass, then what would happen?
We've never really gone into that territory, and I think that's a question that you guys should consider. I think it's, at heart is the definition, right? We don't really have a provision of what would happen. My interpretation is that really nothing would change particularly because each individual statute has already been approved at that point. So that only happens after every 120
So the
groups
budget
have
is
voted
more
on
of,
it.
you're saying the budget itself is more of a symbolic vote, and that it's already, each of these groups have already been.
Right, they've already been allocated their funding and the funding's been approved, so.
But, okay, but the budget itself, even if it's symbolic, still is a definitive piece of legislation.
It is this year because we voted on it, but it's not necessarily, it doesn't have to be. And I would actually argue that it's not the meat of the money, right? The meat of the money is each individual group. You could call it just like a summary sheet. So, I mean, we had this discussion at one point, Chief Justice Raphael, and I can replicate it here, which is basically, you know, if you veto the budgetary statute that is the Chanticleer, then does it stay on the summary sheet, but it's not, you know, doesn't actually have the funding? I think that's exactly the kind of question that we need you to rule on.
So can I just clarify something?
Yeah,
You vote for each group's funding,
correct.
and then that all gets put on one sheet, which then gets voted on again.
It wasn't one specific sheet, there was not like a
Like-
summary sheet, but yes, we vote on
You
the
vote on it
entire-
like not like.
And, right, so
maybe
the reason we do that is
metaphorical
because
sheet
of
at
this bylaw provision, which I read, which says the final annual budget may also be passed by a majority vote. It doesn't say that, you know, it has to be. Now, if it did say that it must be approved by a majority vote, then I think it would be appropriate to say that the annual budget is a single unitary piece of legislation, in which case a line item veto is not appropriate. Is that clear?
Yeah. I think Justice DeBach had a question.
Okay, so I understand what you mean by, you know, like the annual budget is an aggregate of, or an aggregate of record for a lot of other statutes that are individually voted on. However, in the actual definition of veto itself, it seems like the language is quite specific in saying that the veto is for the Chanticleer of the amount of $20,000 in the annual budget that's approved, but not the actual statute that voted to fund the Chanticleer. So I was just wondering, like, it seems like that the President Mecklai made that distinction when she was actually declaring for veto.
I understand where you're coming from with that, but I don't necessarily agree with it. I think the language is vague enough that it allows for interpretation one way or another, and this is the contention that we're making based on the legal definition that I'm explaining.
Also, until midnight tonight, I still have the right to issue a veto, so,
Of what?
of the annual budget, of the budget.
We've already issued the veto budget, is that correct?
Yeah, but, so I could write that I am issuing a new veto that would trump the vetoes that have been issued already.
So what is this?
So,
Like,
yeah,
this is the veto that we have, but if that is a deciding factor in that the veto is too vague,
I don't think either side was arguing whether or not this veto is too big.
okay.
She was responding to the question from the Justice.
Wait, so is this an active veto or just a draft or something?
So
It's
this
an
is,
active
this
veto.
is not a document that we have a copy of. This
Yeah.
was submitted to us just recently, as in here, and is a full veto of the entire annual budget.
Right, which is to clarify on the, assuming that this case implies that there are not individual budgetary statutes. And so as Pro Tem Hopkins mentioned, it was sort of a responsible move in which we were implying that the money that is to be spent is so important that the question of whether or not this, first or second reading needs to happen again must be answered if we are not allowed to veto individual budgetary statutes within the summary sheet of the annual budget.
Well, so my question is so if you are vetoing the annual budget, is that also effectively vetoing each of those 120 votes that happened on those separate?
Right, so to
different
clarify, and
votes?
I can rewrite this out on there and re-sign it but that active veto of the full annual budget only comes into effect if my veto of the budgetary statute of the Chanticleer is nullified.
So this only comes into effect so this is like not an active veto?
Not an active veto.
Okay, this
You
is
just
a
said-
draft of a veto.
A draft
Is
of,
it signed?
it's,
It is signed, which means it is.
That's an
So
active
so
veto.
then it is an active
Unless you
veto.
rescind your veto.
then I will.
Right, so that's the idea, is that there are like right, we're trying to be responsible with our money here, so there are like different ways that you could go about
I
doing
mean,
it.
if you would like me to formally declare that I rescind the veto and
So
a
I,
decision is issued.
There is no method for rescinding a veto.
It's already vetoed.
if someone would, I mean, you're welcome to file another complaint or another case about how one would rescind a veto. That could potentially be an interesting question, but I think that because this is signed, it is an active veto, and because it was presented to us, it would,
I said that it's an active
it
veto.
would constitute an active veto.
Right, so assuming that there isn't a case to say that I don't have,
All else is irrelevant at this point because we have an active
Because
veto.
Yeah, well, let me say
Supersedes-
something else here
this,
about.
hold on, this, I believe, as I understand, this supersedes any other veto you've passed in the past. Correct?
then do I need to write another veto to supersede this veto?
Let
So
me just explain
we
something
cannot
that's
direct the
important.
president in the way that she issues vetoes,
Right.
however, people are more than welcome to bring challenges to that
Right.
act.
Yeah, let me just explain, just so we have a logistics understanding here. Our last meeting of the year is tomorrow night, right? So this is not, I understand that we're trying to be judicial in our decision-making process here, but do consider that there is a time limit to how all this goes into effect, right? So if we had unlimited time and this case was being done within 2 days of the last Senate meeting, then I think the situation would be different.
Unfortunately, it would be inappropriate for the judiciary to consider political expediency as a factor in whether or not to strike a piece of legislation.
Well, I don't
or
agree
to
with
strike a
that, that's
veto.
y'all's decision to make, so.
But I appreciate the concern. You may continue.
Okay, so going back to our definition thing, the third point that I would make on the omnibus definition is that there are these external considerations. So as we mentioned, the legislation requires 2 readings that are 5 days apart, and you just basically said that you wouldn't consider this, but the budget is usually passed on the final or the penultimate meeting of the year. So it's not particularly appropriate to have this kind of back and forth over veto of the whole thing and then have a second reading, have 2 readings and then rediscuss it. So I do think that is important for you to consider in kind of the nature of the decision that's made. Any questions? Okay, so the last point that I'll make, and again, this isn't necessarily a contention and obviously wasn't mentioned in the letter, but it's important to note that for the sake of the decision that you end up writing, ultimately, and Tanner, I think, was the one that made this motion, so, and you'd have to go back and check the video, but my understanding was that the original allocation was $0. It was then, there was a motion to amend to $20,000, and then that was a decision that was made by the Senate in addition to the final decision on the whole Chanticleer's budget. So,
Yes.
right. So again, the contention isn't that the veto applies to the motion that was made, but if you are so inclined to rule on a motion that could be, or an act of the Senate that is not a piece of legislation, I think that could be relevant here. But again, I know you said over and over again that you don't intend to do that. So again, just to kind of reiterate.
We're not saying what we're intending to do.
Okay. My point is clear. Just to go over kind of what we're saying here, to clarify for everyone again, this isn't necessarily a particular line item veto. We're all pretty much in agreement here that a line item veto is not appropriate, given national precedent, which we are in this case applying to DSG. However, we would encourage you to make a decision on the definition of what the annual budget actually is. Is it a unitary piece of legislation, or is it a conglomeration, or rather omnibus package of individual statutes or budgets of groups? And what we would use as evidence to support our claim that it is an omnibus package, again, three pieces of that definition. We have 2 readings and an individual vote on each specific piece of legislation, the budget for each group. The SOF bylaw, Title IX, Section 8 says the annual budget may also be passed by a majority vote. And then finally, the external consideration that it requires 2 readings, and it's improbable and an unnecessary burden, basically, to have to go back and forth, over a whole piece of legislation. So I think President Mecklai is going to talk about the requirement for objection that was brought up earlier, but that's all that I have to say, unless you all have any questions.
Yeah, so just the one thing that Vice President Lockhead mentioned sort of at the beginning of this that I don't think is particularly relevant to this case, but was just sort of the idea of whether or not the president should have to justify herself in sort of the veto that they put forward. So first of all, there's nothing in the Constitution that indicates that the justification has to be in writing. So I think that any sort of justification, for example, there was witnesses that could attest that there was a verbal justification in the last DSG executive board meeting to the executive vice president, I think would stand. But secondarily, the president shouldn't have to justify themselves to anyone, and it implies that a value judgment should be placed on the judiciary to decide, or on somebody to decide, whether or not that justification is worthy. But a executive veto is just that, an executive veto, where there isn't a group that decides whether or not that veto is worthy. They just decide whether or not they will allow that veto to stand. So that was just something that we wanted to mention.
Are you ceding the rest of your time?
Yeah.
You have.
9 minutes?
Yeah, 9 minutes. But you don't have to take that full time.
Okay, I will. So I'm going to address 4 really quick things. First is in direct response to what President Mecklai said about the justification for the veto. Let's assume that you're going to actually consider this in your ruling, so I'm just going to make the point really quickly. Obviously, there is nothing specifically in the Constitution that states that the justification has to be in writing. I would assume that if we think that her whispering to a friend, hey, I have vetoed it because I don't like the Chanticleer, and then said nothing else to anybody ever, no public record, there was not a statement to Senate, it was just like to her BFF in her dorm room
But
late
does
at
she
night.
have to make a public statement and like verifying why she vetoed it?
Right, so that's the question that's before you. I would argue that that is insufficient notice to Senate of her justification. So you might say, well, if she...
Just a minute. Go ahead.
What?
Are we not, like, based on what we've discussed, are we, because President did indeed issue this long-form veto that was addressed to the Executive Vice President, insofar as she's required to by the Constitution, I would say that, regardless of what she said verbally, because we now do have the long-term veto within the 5 days, that seems like sufficient representation of the justification.
Right, so that's exactly what I sort of prefaced my comment with, was like, let's assume that, we are not contesting that the justification she gave to EVP Guarco in her long-form vetoes was insufficient. We are merely stating that it would be prudent of the judiciary to address the question, given that the original grounds of the lawsuit were on a veto that did not contain an explanation. So both in terms of practicality and in terms of the origin of the lawsuit, we think it would be prudent to address. If you don't feel that way, that's fine. I'm frankly not that worried about it. She also said that, and the second point, and then I'll move on quickly, is the question is not whether the justification was worthy. We're not contending that it is our place to suggest that the justification was or was not sufficient, but rather what actually constitutes an actual justification. In other words, if she said, I vetoed the annual budget because I don't like the font, we're not, and she said it, she explicitly wrote it to EVP Guarco, she said it in front of Senate, we think that's fine in terms of her issuing an official justification. It would be constitutional. Is it productive? No, but that's not the question, right? The question is only whether or not it was actually, the justification was made. We don't think
So this is an interesting question, and one that potentially the judiciary could consider in the future, but is there any harm, is there any a material harm or any kind of harm that people are experiencing now, given the fact that the previous veto has been superseded by this veto, which does present a written explanation?
Yeah, great question. So I would argue yes, because if it is the assumption that the Chanticleer would not be able to gather funding in the future unless the Senate understood the grounds upon which that veto is made, then it would effectively prohibit the Chanticleer from having any shot in a successful reintroduction of the budget, given the president's decision. In other words, for her to say, I vetoed, so, but
let that talk, please.
But to be clear, the Constitution only says, as the President pointed out, that it says the President's specific objections. It doesn't, give the type of substantial objection. She, in theory, could, if she issue an objection saying, I don't like the font, as long as she specifically says, I don't like the font.
Correct.
It just doesn't have to be specific. It doesn't say it has to be, particularly meaningful.
Correct. Yeah, I think it's fine if she wants to say, I don't like the font. We just think that she has to submit that in writing to the EDP. That's for you to consider. In the interest of time, I want to move on to the more consequential discussion. So, is that fine? Do I have to?
Well, so the question that I'm struggling with is that, let's say that the previous veto, so what you're defining as a line item veto never happened, never
Sure.
existed. How would the situation of it never existed and this being presented be different from, it did exist, but has been since superseded by this?
Sure, so if we assume that the original one is just irrelevant and now it's gone and pretend like it never happened, then this is just completely irrelevant because we believe and are not contesting that the updated veto that you believe supersedes actually was in violation of her constitutional obligation to provide justification. So, does that make sense? So in other words, it's,
Right, but so then is there any sort of harm experienced by the fact that the previous veto, I mean, we can't pretend that it didn't happen, it
Sure,
did.
so let me answer that. Right, so we would argue that the reason why it's harmful is because in the meantime, senators have to construct an argument for why the Senate should vote to fund a student group. If there is no justification at all for the grounds upon which that veto is issued, it is not possible for that time to be given to senators or to that group to create an argument to be funded. In other words, by not issuing a justification for the veto, it prevents the student group from really actually having any chance at all of regaining their funding by making an argument to Senate. So that's why it's actually harmful in practice. But again, I want to move on to the more substantive claims. So the first thing that, is that, can I just keep going, or do I have to be responsive to the question until I'm great. So the first question is, Brian said, well, the Senate votes, first thing he said, the Senate votes on each group as we go through it. And he said there's 2 readings on each group. So I'll point out that during Senate, if we want to refer to the video, not only is that not true in terms of the Constitution because it's not specifically outlined that every single group has to receive 2 readings individually, but it's also not followed in practice. The SOC chair, during the second reading of the annual budget, did not go through every individual group because he understood, as well as the rest of Senate, that the only thing that gets 2 readings explicitly is the first reading of the entirety of the annual budget and the second reading of the entirety of the annual budget. The Catholic Center is not entitled to a specific reading of the Catholic Center's individual budget twice. That's the huge distinction that we're making here, and for that reason, we believe that the annual budget must be considered as a whole. Why is that the case? Because individual statutes are not given 2 readings. So again, that's again a really, really important distinction if the question is definitional, right? Like, is the annual budget a statute? We would argue no, because individual groups are again subject to the 2 readings of the aggregate of the entire budget, and therefore any decision to veto part of that budget is not valid because it falls within like the annual budget, which by nature has to have 2 readings for the entirety of the groups. And that's why we vote on a conglomeration. So the second was that he said, and this is again really important, he said that the final budget may be passed by a majority vote. So he cites the link, and this is in the SOFC's section 8, he says that because the language says the annual budget may be passed by a majority vote, therefore it is not actually necessary to pass the entirety of the legislation, but rather only to pass individual groups within that annual budget. So we think this is kind of like misconstruing what the language actually means. So we contend that the language, the final annual budget may be passed by a majority vote, does not mean that it is not subject to an entire majority vote, but rather that the Senate is not obligated to actually pass the entirety of the annual budget. If it said the final annual budget must be passed by a majority vote, that does not change whether it's subject to a majority vote, but rather whether the Senate has an obligation to actually pass something in the affirmative. So that's what the main language is. So it's obviously it's very poorly written, but I think it's very clear that that does not suggest that the annual budget somehow is not actually subject to a vote at the end of all this. That's not only is clear in the Constitution, but it's also clear in practice because for the past, 10 decades that DSG has been a thing, it's always been understood that the annual budget was subject to one final vote. Those are like the big things, right? Like the third that Brian brought up that I'm not going to give a lot of time to because I don't think the argument really has a lot of merit is that you should consider external considerations in how you rule. I obviously do not think that either political or logistical expediency should have any bearing on how you read the Constitution. And it's also very clear that were you to make a decision on the grounds of what was logistically expedient, that would clearly benefit the defendant who just wants to sort of make her decision about what is and what is not legitimate in terms of funding and then just move on. So we think that you should make your decision based on what the Constitution says that you should do. And I think you know that and I know that, but I think it's worth mentioning things. So if there's any questions, I'd like to answer that.
I think Justice Dabaki had a factual clarification for Ms. Mecklai.
Sure.
So just about the testimony that you did earlier, you said that when you gave your first short form veto to the Executive Vice President, you gave a verbal reason for your veto?
Yeah.
Mr. Worker, would you stipulate to that she did give you a verbal reason that she handed you the written letters?
No.
Oh, there was no verbal reason as I handed him the veto. It was to the whole executive board during a meeting, but it was still during the time frame with which like I am allowed to veto. And so I just reissued a veto with a written justification within that time frame.
And the veto of the entirety of the annual budget was submitted to me through email.
And I might add quickly before continuing to follow up on this point is that we are arguing the reason that it has to be written is because there is not a, if we believe that that is a legitimate basis for her to make her justification, there is no legal distinction between two offhanded words whispered under her breath to the executive vice president at Shooters and a formal declaration in the middle of an exec meeting about what is and what is not a justification. So for that reason alone, you should clarify that the declaration of veto and the explanation has to be written down.
And to be clear, it has been written down in this case. The clarification would be for future precedent.
It is not consequential, but it is important to think about.
Thank you, everyone. With that, that concludes oral testimony for Lockhead and Guarco v. Mecklai. The judiciary will now deliberate. We do hope to issue a formal decision by this evening, considering the time.
Wait, do we not have a response?
I did announce at the beginning that there was 30, 35.
Oh, I didn't know.
We'll do our best to give you all a shortened explanation of our decision this evening. A formal written opinion may take several more days considering it is exam time, but we will do our best to be timely with that. We will certainly have word to you about the outcome of the case as soon as possible. Thank you, everyone.
Thanks. So fun.
Could you see the veto? Can we see that?
Ms. McCoy, could you submit the electronic version of that, please?
Yes.
Yeah. It's getting sliced.
Well, so you could argue no, because it's only as like is expressly mandated to be in line with the Constitution, and like it was on the standard, for example, of time.
Oh, I already
So,
sent it to you.
like,
Sorry, I sent it to you.
like in practice, you're right,
I
she
blocked
was in
that,
court,
but-
but
I sent it to your Gmail.
pray on me.
Where'd you write it?
Just one
Yeah, I
back.
just want that.
Oh, no, but were you asking a question? Or were you asking me? Oh, it's not either.
Please clear the courtroom though.
Yeah, sure.
Thank y'all.
Thanks for bringing this pic. I got these from Looks really nice.
Also,
Yeah, I know, I agree. I think someone does that.
Well, thank you, customer. Bye.
Okay.
Thanks.